going to let the attorneys in. I have an attorney whose connection is taking a little bit of time to connect and join us in the courtroom. It will probably take an additional few seconds. Chief Judge, may I open court?
Please, thank you, Anne.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3094, United States of America versus Morris Jamal Johnson, appellant. Ms. Williamson for the appellant, Mr. Coleman for the appellant.
Good morning, counsel. Ms. Williamson, when you're ready, please proceed.
Good morning, Your Honors, and may it please the Court. Your Honors, Morris Johnson, an honorably discharged military veteran and firearms hobbyist, was convicted of 6 counts related to his possession of 2 modified 37mm shells. The government agrees that 4 of Mr. Johnson's convictions should merge into 2. The government also agrees that Mr. Johnson should get a hearing on his ineffective assistance of counsel claim. But Mr. Johnson's other 2 claims also warrant this court's relief. First, Mr. Johnson's 2 counts of conviction for possessing 2 modified shells in the same place and at the same time constitute a single course of conduct. Under District of Columbia law, courts presume that the unit of prosecution for weapons possession offenses is the instance of possession, not the number of individual items possessed. That presumption applies unless D.C. counsel expressed a clear intention that the statute permits multiple convictions. There was no such intention here. Accordingly, this court should remand this matter to the district court with instructions to vacate.
I'll ask you a question about this part of your argument. For the statute, it speaks in terms of a person who possesses a weapon of mass destruction, but it also speaks in terms of a person who manufactures. So it says, I think it says a person who manufactures or possesses.
That's right.
Would you say the same argument that you're making now applies to manufacturing also? So that, for example, if somebody, if the police search a house and they see, two of the same object, both being manufactured, let's say in separate rooms of the house, but it's one house, would it be one manufacturer, even though there's 2 different objects being manufactured in 2 rooms of the house? Or would it be only one manufacturer because there's one process of manufacturing going on in 2 different places in the house?
Your Honor, the question would be whether this was one course of conduct. The government could allege that those were 2 separate courses of conduct, such that possession occurred separately. Under the circumstances Your Honor outlined, likely that manufacturer would constitute 1 count.
Why is that? Because it just feels to me like with manufacturing, it seems like there's 2 manufacturers going on, not just one, because there's 2 machines, let's say, that are doing the manufacturing, and they're in adjacent rooms of the house. It doesn't feel like one manufacturer, even if it's the same person doing them, and even if it's the same person doing them at the same time. It does seem like there's 2 acts of manufacturing going on, and it's not clear to me why the analysis would be different or the word that's right next to it in the statute, possess?
Yes, Your Honor. I think here the question is whether the D.C. Council expressed a clear intent that this be that more than one count of conviction be possible under the statute. And for manufacture, as for possession, there's no such intent in the language of the statute or in the legislative history. The court would look to that.
But even your argument is limited to, I think you said, and I think your brief says, same place and same time. And what's a place? So if it's the same person and they own adjacent houses, and there's one being possessed in one house and there's one being possessed in another house, is that the same place?
Your Honor, the presumption would be that those are different places, but the government could allege and
why are they different places? It's the same person who owns both houses, and it's the same person doing the possessing in both houses. What the place? I thought in your brief that the place was identified as the District of Columbia.
That's right, Your Honor.
The two houses adjacent to each other are both going to be the District of Columbia. So why would those be two different places?
Your Honor, in the facts of this case, Mr. Johnson's indictment alleged only that the possession was in the District of Columbia, but were the government to allege that possession or manufacture occurred in two separate locations, the government could put on facts at trial demonstrating that the possession occurred in two different courses of conduct. So, for example, in Your Honor's hypo, those two separate locations in which the individual was manufacturing, even though owned by the same individual, may constitute two different courses of conduct for purposes of the statute.
Oh, so I guess I wasn't, does the term just on the way the government alleges it? Because then you could allege two different rooms in the same house as being two different places too, or two different places in the same room as being two different places.
Yes, Your Honor, under the terms of the statute, the D.C. Council intended for there to be one punishment for one course of conduct. The government could allege that there were multiple instances of possession and attempt to prove that there were multiple instances of possession. In this case, the government didn't attempt to do that. The allegation was that Mr. Johnson possessed the two modified shells in the District of Columbia and that he possessed them on the same day in January.
Let me ask you one last question along these lines for now at least. Your case in some ways has the best scenario for your side because the objects seem to be basically facsimiles of one another, and it's largely in the same place, and as far as we know it's at the same time because they were discovered at the same time. What if there were two dramatically different weapons of mass destruction? You know, one of them is a dirty bomb and one of them is a shell, and they're both being possessed in the same house at the same time, and they're discovered in the same search. Your argument's still the same, that you're only perpetrating one act of possession, even though one of them is a dirty bomb and the other one is a shell.
Yes, Your Honor, it would be the same argument, and Bean demonstrates this. In Bean, the District of Columbia held that it was one course of possession when a defendant possessed both a knife and a rifle, and the court raised this issue sua sponte, and possession in that case occurred in two different locations in a vehicle. One of the items was in the front seat, in the passenger seat of the car, and the other was in the trunk. And the District of Columbia Court of Appeals sua sponte said that was one course of possession.
Was that a possession statute, or was it carry?
That was in Bean, Your Honor.
Yeah, in Bean, did the statute bar possession or did it bar carrying? And now maybe there's not a difference.
It barred carrying, but the statute was quite similar. It was carrying a pistol or any deadly or dangerous weapon. And in that case, the statute, there was even stronger suggestion in the language of the statute that could be read to permit two different counts. But the court said no, that under those circumstances, there was only one count of possession permitted. If Your Honors don't have any additional questions on that at the moment, I'm happy to to move to the closing argument issue. The district court abused its discretion by limiting Mr. Johnson's trial counsel's closing argument to only some, not all, of the favorable inferences from the record. Trial counsel wished to point the jury to the possible inference that a key government witness may have distorted evidence, although the district court permitted trial counsel to argue some inferences from the record. The district court did not permit trial counsel to argue all permissible inferences. That, Your Honor, cut to the core of Mr. Johnson's case and was error. If Your Honors have no more questions, I will reserve the remainder of my time for rebuttal.
Oh, I have a couple of questions. Is our standard of review on the closing argument issue you raised abuse of discretion?
That's right, Your Honor.
Why, then, is this an abuse of discretion? In other words, do you have any burden to show that, say there's three inferences, you get to argue two, and then you would have to show that, or would you, that the third inference you were not allowed to argue was a key part of the theory of the defense? In other words, what would you have to show to prevail on an abuse of discretion?
Yes, Your Honor. We would have to show that the district court did not permit trial counsel to argue inferences that cut to the core of the defendant's case. So under Your Honor's scenario of two inferences permitted but not a third, if that third inference cut to the core of the defendant's case, it would be an abuse of discretion not to permit trial counsel to argue that inference as well.
So how does that work here in your case?
Well, Your Honor, in this case, Mr. Johnson's core theory was that the government hadn't put on evidence supporting the inference that these were firearms under the statute. So the testimony of Agent Campbell about how the weapons were disassembled and how they appeared when he disassembled them, that cut to the core of Mr. Johnson's theory.
And what you wanted to argue was, specifically, I thought that it's turned on the district court making an evaluation of whether or not the evidence showed the negative inference as to the officer.
That's right, Your Honor. The district court permitted Mr. Johnson's trial counsel to argue that generally this agent's testimony couldn't be trusted, but right. Trial counsel wished to point the jury directly to the inference that it could look to this prior district court's judgment about this agent's handling of evidence and say from that, perhaps this agent may have distorted evidence. And
so why is it an abuse of discretion to the district court to say, essentially, that's another case, it's not before us, we don't know the facts, etc., and I'm just not going to allow that here when you are allowed, based on the evidence in this case, to argue the basic inference and not the specific example in another case not before the court?
Yes, Your Honor. I think the reason it's an abuse of discretion here is because it cut the theory that this agent may have distorted evidence specifically cut to the core of Mr. Johnson's case. So if the district court had not permitted the evidence of this prior district court's finding about this agent, then there wouldn't be evidence on the record to support the inference. But once the district court permitted that evidence, there was evidence on the record to support an inference. And under Deloche, the district court must permit trial counsel to draw all reasonable inferences, including inferences that are in the court's words, untenable, forced, unnatural. So the standard is such that defendants' counsel are given quite a bit of leeway to specifically point the jury to the theory of the case. And here, Mr. Johnson's trial counsel was not permitted to draw all of the possible inferences. For that reason, it was an abuse of discretion.
Well, all I'm getting at is that's what I'm trying to understand is when it is an abuse of discretion and when is it simply a reasonable exercise of discretion. When the defense gets to argue its basic theory that you shouldn't trust the officer's testimony.
Yes, Your Honor.
Is the argument here that where you have such a demonstrative demonstration of this, that it's just blatantly an abuse of discretion not to allow the defense to argue this?
I think, yes, Your Honor, it's certainly right that the more evidence supporting an inference and the more that the inference cuts to the core of a defendant's case, the more likely it is an abuse of discretion if the district court...
I understand that, counsel. I need specifics because I'm thinking of cases, gruesome cases, where the defense wants to introduce, 2 boxes of photographs of the brutal stabbings or the killings of people, and the district court says, well, you can introduce 1 box, but not 2. Or he or she refines it even more. You can reduce 10, and that's it. And I'm trying to understand why you think this is a different situation. Because I'm suggesting there that we normally defer to the district court on matters of inflaming the jury, and that would be so in the gruesome picture case. I'm trying to understand this, and I do understand your theory, but I want to understand how it works in this case.
Yes, Your Honor.
I pose to you, if the district court let you put in 2 of the 3 inferences, what is it about this 3rd inference that is so devastating to getting the theory of the defense before the jury? Yes, Your Honor.
Under your hypo, the district court certainly has discretion as to limiting the amount of evidence, and in your hypo, permitting 1 box versus 2 or 2 boxes versus 3. But once that evidence is admitted and it's already before the jury, the question for closing argument is whether trial counsel is permitted to draw the jury's attention to that specific evidence.
But I mean, didn't the district court premise its ruling on the legal theory that you don't have to allow an argument of evidence that's not been admitted? And that's what the district court said. Now, if you agree with that, I don't see how there can be an abuse of discretion. And I think the district court said that what went on in Kentucky or wherever it was did not involve tampering. And so the district court was essentially saying, you don't have any foundation, so to speak, and that's that. So I'm not letting it in.
Yes, Your Honor. I think...
I mean, do you agree with that legal premise, which is what the district court was relying on? We're not going to let you put on an argument that does not have any kind of evidentiary premise?
Yes, Your Honor. Certainly I agree that if there were no evidence supporting an inference, trial counsel wouldn't be permitted to argue that. In this case, though, trial counsel didn't want to argue that this agent tampered with evidence. That's to say, trial counsel didn't want to suggest that this agent testified about or produced photos about things that were not actually in evidence, but rather trial counsel wanted to argue that perhaps this agent had exaggerated the state of evidence. And I know that the difference there is subtle, but I think it's meaningful in this case because, for example, if the flachettes were not in the device, but separate from the device, if a fuse were not in the device, but separate from the device, if powder were not in the device, but separate from the device, that would make a difference as far as whether that were a completed device or whether that were a combination of parts. It would undermine, or might in the eyes of the jury, undermine the jury's understanding of Mr. Johnson's culpability, number one, and whether he had actually manufactured or possessed items barred by the statute.
All right. Counsel, let me make sure my colleagues don't have further questions for you at this time.
No, I don't.
Government will give you some time for rebuttal. Thank you.
Thank you.
Mr. Coleman.
Thank you. Good morning, Your Honors. Nick Coleman for the United States. I'd like to begin by addressing the question of the merger of appellants' convictions under the D.C. Code, weapons of mass destruction statute, before briefly addressing the closing argument issue. We respectfully submit that appellants' convictions for possession of 2 weapons of mass destruction under the D.C. Code do not merge. And I think that there is a crucial distinction to be drawn between the statutes that appellant is citing, which deal with the carrying of weapons, a prohibited carrying of weapons, or the possession of those weapons during the commission of another offense, as opposed to the statute here, which is intended to implement an absolute ban on a certain kind of weapon, in this case, a weapon of mass destruction. The statutes are not, in fact, equivalent, and thus the legislative intent, I think, is much different. If you take a look at certainly at the legislative history and at the statute itself, it's quite clear that what the D.C. Council was trying to do was to essentially implement an absolute ban on the possession or manufacture of weapons of mass destruction within the District of Columbia. That ban would be undermined, we respectfully submit, if the court were to take a sort of in for a penny, in for a pound approach, in which there's no difference between the possession of 20 weapons of mass destruction, which of course could then be placed all over the city, as opposed to simply 1. And I think it's telling that
all over this, if the person is found placing them in 20 different places, and it were alleged that there were 20 different acts of possession because they were placed in 20 different places, that might be one thing. But it seems like the argument here is that because they were found in the same place, in the boxes, either the same box or boxes right next to each other in the same house, and the allegation didn't suggest that they were found in 2 different places, then that's 1 act of possession. And I mean, I guess I could see it either way, but you would agree, I think, that the DC opinions are the relevant body of opinions, right, for a DC statute. So in other words, if there was a decision that's right on point, we would be bound by that. So if that's the case, if there's no dispute about that, then Ms. Williamson did point out being, and I know that you're saying carry is different possession, and certainly they're different words, but what is the difference? Because carrying and possessing are both things you do with a weapon. And are you suggesting that if this statute were the exact same, except it just barred carrying weapons of mass destruction, that there would be a different result as between carrying a weapon of mass destruction and possessing or manufacturing a weapon of mass destruction?
I certainly that would be a much harder case for the government to argue. I do think that there is a significant difference here, and part of the reason why is if you look at, although we tend to think sort of colloquially as that the carrying a pistol without a license statute, the carrying a dangerous weapon statute, as implementing a ban on firearms within the district. Technically, that's not actually what they were doing. The firearm itself was not directly prohibited by any of those statutes. The mere possession of the firearm was not prohibited. It was prohibited only under certain circumstances. One, you could not carry it on your person if you did not have a license to do it. Now, of course, the district didn't issue licenses until recently. You also couldn't have an unregistered firearm. Now, that was the statute analyzed in Hammond, which of course we've described in our brief, and we think is actually the better analogy here. But even things like knives, which are covered by the carrying a dangerous weapon statute, it's not that the item itself was banned or banned under all circumstances. It was only its carrying or use under certain circumstances that was prohibited. Not so here with the weapons of mass destruction statute. That simply says you cannot possess it, you cannot manufacture it, you cannot possess it. This statute is different in kind. It's intended very clearly to implement an absolute ban. And
I'm sorry, go ahead, Sri.
No, please.
The DC at Bean, I think, if I remember correctly, they're setting a presumption that is inconsistent with what, in other words, if there is a benefit of the doubt, it would go to the defendant here, as I'm reading the case law, and not go your way. And this is an odd statute because a violation can be punished by imprisonment for life. So whether you have 1 or 600 is not going to make any difference. I realize this is very close in that there's no clear guidance in the evidence. So we're trying to scratch out, well, where do we look? The DC case law is not supporting you, as I read it. I just don't see where you have any strong support for your position. We're looking to see whether someone possessed a weapon of mass destruction, 1 or 700. And if so, there's a possibility of imprisonment for life. And I don't see how you get multiple indictments out of that. I just don't see it out of the line. I see what you're saying, but it seems to me if there's an ambiguity here, our sense in these criminal cases is it cuts against the prosecution. You got to have something better than, well, but you could read the language our way. That doesn't work for me in any event. And I don't see anything in the DC case law that works for you.
So I think that Hammond, Your Honor, I respectfully submit, is instructive here. In Hammond, obviously there were arguments to be had on both sides as to whether or not the possession of an unregistered firearm statute should be read that its unit of prosecution should be the firearm, or whether it should just be the possession of any amount of unregistered firearms. And the court there looked carefully at the purpose behind the statute, and both its language and what it was designed to implement, and concluded, in fact, that the unit of prosecution was the firearm. I do agree with you that under Bean, if there are serious doubts, then in general those must be resolved in favor of the defendant. I mean, that's a basic implementation of the rule of lenity. But I think, again, I don't think that there is here, to borrow the sort of lenity cases, the kind of grievous ambiguity that requires this court to conclude that, again, in for a penny, in for a pound.
Grievous ambiguity?
Well, that's what the Supreme Court did say in Chapman, Your Honor, and I understand exactly what those words mean can be argued.
Yeah, right. But clearly an ambiguity. I'll give you that, and I think it's a very clear ambiguity. But and if you have that, it seems to me that's enough for you to be in trouble. And then the oddity in this statute, it takes one for you to get the worst of what the D.C. Council had in mind. All you need is one.
Well, except that I think, though, I do understand Your Honor's point about the sort of very severe potential penalty.
Right.
But, of course, it just says up to life. There's no mandatory.
No. I understand the limitations of it's instinct now. We're trying to figure out where you go with this. And if you don't have anything more than you're presenting, I think it's a troublesome argument.
Well, I do think, though, that the implications of what Appellant is arguing are also equally troublesome. Obviously here Appellant was not charged with manufacturing a weapon of mass destruction, but to take a point that Judge Srinivasan brought up, that under Appellant's argument, and Appellant, I think, forthrightly acknowledges, the implication of Appellant's argument is that you could manufacture as many of these weapons of mass destruction as you want, and you would face only one conviction. I don't think that is a reasonable implication.
Yeah, but one conviction for life. I suspect that it weighs very heavily in the sentencing if someone manufactures one as opposed to 27. That's going to affect how the sentencing is going to go, and the sentencing has the possibility of up to life, or one or up to 27. And so that's why the argument you're advancing just doesn't ring true to me, because if there are multiple things going on, that will be taken account of in sentencing. And the sentencing goes up to life for one and as many more beyond one as you find. So, I mean, it just doesn't ring true as a compelling argument in this situation. The language, and I've gone back and forth on it, but the language just doesn't ring true. And lenity, for me anyway, is a real concern here, the rule of lenity.
And I understand Your Honor's concerns. Obviously, I think, I'm not saying that one can't make an argument. The question is whether or not there is sufficient ambiguity or lack of clarity to require that.
Can I ask you one question to follow up?
Yes,
the way you were drawing the distinction, it sounds to me, in response to both of our questions, is between a ban and a non-ban situation. But with the controlled substances cases, I think there's a ban, right? You can't possess a controlled substance, period. They just want to root out the possession of the controlled substance. But then the controlled substance cases come out the same way as Bean, because you have Briscoe, where marijuana is found in two different places in the same house, but it was considered to be one act of possession of marijuana, even though that's a ban statute, I think.
Understood. I do have two responses on that, Your Honor. First of all, even when you're talking about the same substance, the way D.C. statutes are much like the federal statute. They are based on the amount that you have of the substance. So it's not that if you have 2 tons of marijuana, you are subject to the same penalty as if you have 2 ounces. In other words, those statutes are actually structured in a way that takes into account how much of it you have. It's not so much that it's based on whether you've split up your amount into a couple of different places, but it takes the whole and it tries to figure out how much you actually have.
Well, and I think a statute like this takes into account how much by having sentencing up to life.
Well,
that's where if you have to address that, is we're looking at someone who not just has one little, I don't mean to minimize it, one little weapon of mass destruction, or really has this huge warehouse at home. That's going to come into it, be taken into account.
Right, and I think, though, however, when we also need to implement sort of what the legislature wanted to do, and the question is whether it wanted it to leave it purely to the discretion of a sentencing judge, as opposed to, should each device be separately punishable.
Okay.
I think, and again, I would simply conclude with the idea that I strongly suspect that the council members, if you would ask them, would have thought that each device was separately punishable, and that by implementing a ban, that's what they intended to do. So we would respectfully submit that is what.
No, I don't think you want to go there, because if I were teaching in class with the council member and I said, here's the hypothetical, I suspect more would vote the way I'm suggesting. That is, do you need more than one? But in any event, I hear you.
Very well, Your Honor. I'd like to proceed to address the closing argument question.
That one, and then.
I'm sorry, Your Honor.
Why don't you take a minute to address the closing argument issue?
Yes. So the main problem I have here with Appellant's argument is that Appellant now is talking about how apparently Appellant was not permitted to argue that the agent distorted the evidence. I don't recall the word distort being used before the district court. Instead, if you look at page 295 of the appendix, the transcript here, what Appellant's counsel was asking for permission to argue that Agent Campbell did in fact tamper with the evidence. Appellant here today seems to be saying that that's not what Appellant wanted to do, but that's certainly how it was phrased to the district court. I think the court correctly concluded that the Kentucky, the ruling from Kentucky was not a ruling that Agent Campbell had tampered with any evidence. I'm not entirely sure what distort means here, but if the question is whether he exaggerated or mishandled evidence or shouldn't be credited in describing that evidence, he was permitted to do all of that.
But the fight in the district court was over tampering, right? Being able to.
Yes, exactly.
Well, that was what I thought, but go ahead.
Right, and that is, but I haven't heard Appellant yet argue that is specifically what Appellant should have been allowed to do. But as far as I can tell, that is the only thing that appellant was not permitted to argue, and it seems to me that the district court permitted everything else. So again, I guess it depends on what appellant means by distort. But if by distort, exaggerate or mischaracterize, or or just shouldn't be believed about the description, that was all permitted. And so I don't think certainly appellant has shown any abuse of discretion in how the district court approached how appellant could use that prior ruling. If there are no further questions, we respectfully submit that the judgment should be affirmed as we've stated, with the exception that certain counts should be vacated as merged, and the case should be remanded for consideration of the ineffective assistance of counsel claim. Thank you.
Thanks, Mr. Coleman. Ms. Williamson, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honors. First, on the point about the District of Columbia weapons of mass destruction counts, the court should view Bean as guiding the court's analysis here. Bean sets out the exact analysis this court should follow. It's important, Your Honors, that the D.C. Council, when it enacted the statute, was legislating against the backdrop of these existing cases. Cormier is a case from the 1950s. Bean is a case from the 1990s. The court should presume that the District of Columbia Council knew that these cases existed, knew that it would have to clearly express its intent if it intended for multiple punishments to be permissible under the statute. As Your Honor, Judge Edwards pointed out, we believe that the proper way that the District of Columbia Council accounted for differences in conduct was through punishment, permitting punishment up to life imprisonment. And the court can also look to a different context, the 922G statute, where all courts of appeals have held that multiple violations of that statute merge into one conviction, where a defendant has several items. On counsel's point about the closing argument, at page 293 of the appendix, trial counsel specifically said that he did not wish to argue that there was any tampering. He suggested that there might have been evidence on the record on which that inference would have been permissible, but that wasn't the inference he sought to argue. He sought to argue that the agent in this case had distorted or exaggerated evidence, and that was the way that the district court curtailed the argument. If Your Honors have no more questions, we would respectfully request that the court vacate Mr. Johnson's 6 of Mr. Johnson's convictions because of the abuse of discretion on closing argument. We would also request that the court vacate and remand this matter for a hearing on the evidentiary on the ineffective assistance of counsel claim and vacate the duplicative counts. Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. Ms. Williamson, you were appointed by the court to represent the appellant in this matter, and the court thanks you for your assistance.
Thank you, Your Honor.
We'll take this case under submission.
Case number 20-5120, Eric L. Lewis, Appellant versus United States Department of the Treasury and Financial Crimes Enforcement Network. Mr. Gordon for the appellant, Ms. Chung for the appellees.
Morning, counsel. Mr. Gordon, please proceed when you're ready.
Good morning, and thank you. May it please the court. We are here today because FinCEN mistakenly believes that its commitments to various foreign government agencies supersede its FOIA obligations. And that mistaken belief infected every aspect of its response to Lewis's FOIA request. It explains why FinCEN has improperly asserted Exemption 5 claims over, for example, minutes of meetings with its foreign counterparts, when the law is clear that those minutes would be factual in nature and not privileged. It casts further doubt upon FinCEN's claim under Exemption 7A that its production of any withheld information could reasonably be expected to interfere with unidentified foreign proceedings. And it certainly calls into question the credibility of FinCEN's 11th hour claim under Exemption 7D that it withheld documents in full solely to protect the identities of confidential informants. And along a similar line, its misunderstanding of its FOIA obligations is sufficient to rebut any presumption that it conducted a proper segregability review. Indeed, this court recognized in the criminal defense lawyer's case of 844 F. 3rd at 256, as well as in Meade 566 F. 2nd at 260, that when an agency believes it's entitled to withhold a document in full, and that belief is based upon a misinterpretation of FOIA, a new segregability review is required based upon a proper understanding of its obligations. And that is the situation we have here. It was FinCEN's burden on summary judgment to demonstrate that there were no material facts in dispute and no contradictory evidence in the record. FinCEN did not meet that burden with respect to any of its claimed exemptions. Just to illustrate how the various exemptions have been applied improperly, I would refer the court to the Vaughn Index entries with respect to Group 40, which is at the Joint Appendix at page 264. And Group 40 is described as an email and briefing paper that was sent to a Department of Justice official. And FinCEN claimed Exemption 5, 7A, and 7D over this document. With respect to Exemption 5, all it tells us is that the exemption is applicable because the background material discusses ongoing and future agency action related to BPA. Well, there's no evidence in the Vaughn Index that the record is either pre-decisional or deliberative. There's no identification of any particular policy or decision-making process to which it may have contributed. We have no idea why it was sent or prepared and sent to a Justice Department official. And there's certainly no basis for determining whether any non-exempt information, such as factual material, can or cannot reasonably be segregated. We don't know if the memo has a fact section and then a recommendation section or what. There's simply not enough evidence in the Vaughn Index to justify the Exemption 5 claim. And then when we move on to Exemption 7A, the index states that FinCEN applied a categorical approach and concluded that the records contain or reference material that would fall within a category it describes as the exchange of information with foreign government agencies, which it tells us is exempt for the reasons stated in the El Hindi Declaration. But my first observation is that the index doesn't even say that the records, and this is a quote, concern issues related to pending proceedings involving BPA. And I quote that because that's a boilerplate description that FinCEN used in 17 other groups of records in the Vaughn Index. And we identify those at page 27 of our opening brief. And it seems to me that the absence of that kind of boilerplate description is indicative that these records do not concern issues related to pending proceedings. Secondly, all the El Hindi Declaration tells us is that the documents relate to BPA and that there are ongoing investigations or proceedings concerning BPA. The cases such as CREW, this court's CREW decision, and North v. Walsh, make clear that it's not sufficient basis, that is not a sufficient basis for the court to conclude that the circumstances characteristically support an inference that disclosure would interfere with a pending enforcement proceeding. because the threshold issue before you can get to a categorical approach is some showing that the information in the documents is even relevant to the ongoing proceeding. And so, for example, in CREW, it was a wide-ranging, multifaceted investigation arising out of the Abramoff scandal. And then you had a request for documents concerning time delay. And the government said, well, wait, there are ongoing investigations. And this court said, well, you first have to show us that the documents concerning delay are even relevant to any ongoing investigations. And the approach that FinCEN has taken here doesn't do that, because all they say is that...
Did the declaration not say that there's ongoing investigations?
It says there are ongoing investigations, but it provides no description of them. And all it says is that they relate to BPA. Well, what issues? What types of investigations? What information is in the documents that is relevant to whatever ongoing investigation there may be? Because if you go back to, for example, the rulemaking proceeding, they would talk about all different types of wrongdoing in different parts of the world, and so on. And there has to be some linkage that the information in these documents is relevant to whatever ongoing proceedings. The ongoing proceeding could be an investigation into whether BPA paid its taxes. Well, maybe the information in this, maybe the withheld information is relevant to that, maybe it's not. There's no underlying showing of relevance when they refuse to provide any information about the proceedings or about the documents. It's essentially two black boxes. And you have one box as the documents, one box has some unidentified proceedings. We can't see into the boxes. The court can't see into the boxes. And there's no way of evaluating the actual degree of overlap, to use the court's words, that would justify the categorical approach that FinCEN is applying. So, yes, the release of evidentiary material could interfere with a future proceeding if it's relevant to that proceeding. If it's not, all of their explanations about how the release of evidentiary material would interfere with the proceeding is hypothetical. It's abstract because there's no linkage between the withheld information and the proceeding. And it's an especially acute issue here because, you know, in the typical case that was discussed in CREW, for example, the agency is actually the same agency that's conducting the investigation. And here, there's no indication that FinCEN even has sufficient knowledge about the specifics of these investigations to be able to reasonably conclude, or enable this court to conclude that, yeah, the release of this unidentified information would interfere with those proceedings. I think that the proof of that is that El-Hindi says, he identifies 4 documents out of hundreds that he says FinCEN has specifically discussed 4 documents with the foreign officials or whoever's involved in the proceedings. And they've told us that, yes, the release of those 4 documents would have an impact. There's no similar representation even with respect to the other 200 documents or so that are being withheld under 7A. We could move on to the Exemption 7D claim on this record, where FinCEN says the document contains information from and about confidential informants who have expressly requested confidential treatment of their information. Well, that's not a basis for withholding under 7D. FinCEN is only allowed to withhold information that would reveal the identity of the confidential source. And this index entry makes no such claim with respect to those records. All it says is that we're withholding it because the sources requested us to treat the information as confidential. And in its opening brief below, and this is at docket 36-1, page 26, FinCEN cited Dow Jones, 917 F. 2nd 571, for the proposition that as long as it can demonstrate that the information was provided in confidence, then both the identity of the source and the information he or she provided will be immune from disclosure. And then in opposition, Lewis pointed out that FinCEN was misreading Dow Jones because Dow Jones was a case involving the second prong of the exemption, not the first prong under which FinCEN was proceeding. And it was only in its reply that FinCEN then said, we're also withholding information because it could reveal the identity of the confidential source. Now, even on that issue, it says that information is often singular in nature. That's why it would reveal the source. It doesn't say it's always singular in nature, and there's no indication that the information that's reflected in this briefing paper is information that is singular in nature. And to the extent it's not, you're entitled to it, unless some other exemption applies. In the same, this was just an illustration, the same issues arise throughout the Vaughan Index. If you look at, for example, category 31 at page JA 254, it's a series of emails from 2010 between FinCEN officials. Now, it may be that, for example, for 7A purposes, the emails do contain information which, if disclosed, could be expected to interfere with ongoing proceedings that are pending now. But that inference seems especially attenuated when you're talking about emails from 10 or 11 years ago. I would suggest that the court should require FinCEN to go back, re-review all of the withheld records with a correct understanding of its FOIA obligations, redo its segregability analysis based on proper factors, prepare a revised Vaughan Index, setting forth a proper basis for any information it continues to withhold. If the court has no questions, I'll reserve my time.
Thank you, Mr. Gordon. Ms. Chung, we'll hear from you now.
Good morning, and may it please the court. Ashley Chung for the government. Plaintiff raises many issues in this case, but this court does not need to reach all of them in order to resolve the appeal. If we put aside segregability for a moment, if the court concludes that either Exemption A or Exemption D was properly invoked in this case, the court does not need to reach any other issue. Plaintiff does not challenge other bases for withholding, such as Exemption 7E or the attorney-client privilege under Exemption 5. And these protections, together with either Exemption A, 7A, or 7D, cover all of the documents at issue in this case, except for one record which plaintiff addresses in footnote 5 of his opening brief. FinCEN's statutory mandate is to support law enforcement efforts to combat money laundering, terrorist financing, and other financial crimes. And in support of this law enforcement mission, FinCEN frequently exchanges sensitive, confidential communications with its foreign and domestic partners and other confidential sources. I'm happy to answer any questions.
On the 7D question, I take it you don't take issue with the proposition that to fall within 7D, it's not enough that there was a promise of confidentiality. The source actually has to be a confidential source, right?
Yes, that's correct, Your Honor.
Where is it? How do you piece together that the government is making the argument in response to the challenge to the 7D assertion that the source is confidential as opposed to there having been just a promise of confidentiality?
The government's declarations explain that the confidential sources provide information to FinCEN under assurances of confidentiality. So that makes them a confidential source. And plaintiff doesn't challenge whether or not these sources qualify as confidential sources. I don't think that's an argument that's really preserved in this case. And FinCEN's declarations explain that because the information that was provided by these sources is so closely tied to their identities that revealing even the information they provided would reasonably be expected to reveal the identities of the sources.
And where in the declaration is that? Because I thought they are challenging that. At least they're doing it on appeal. I know you have an argument that there's a forfeiture, but if we look from what happened in the district court, but if we look past that and we're focusing on the arguments that are made on appeal, where in the declarations is that made?
Sure. So if you start on page 178 of the Joint Appendix, this is where FinCEN starts to talk about Exemption 7D. And then more specifically, it talks about the assurances of confidentiality it made to its Egmont partners on page 178 of the Joint Appendix. And just to give more specificity, the Egmont Group is a group of financial intelligence units who joined together for law enforcement efforts to combat international money laundering. And they only agree to provide information to each other subject to an explicit agreement of confidentiality in the Egmont Charter. And then on page 183 of the Joint Appendix, the declaration explains that even outside of the Egmont Charter, there are other explicit express agreements of confidentiality. And then finally on page 185 of the Joint Appendix, this talks about implied confidentiality.
Right, I guess some of that at least has to do with the promise of confidentiality, which I take the point. Of course, there's going to be government investigation programs in which it's important to have a promise of confidentiality in order to encourage partnership and sufficient collaboration. But the statute speaks in terms of revealing a confidential source, not promises of confidentiality, right? And the part of the declaration that draws that connection is early on at 178 and 179, or where are you getting that part of it, that it would reveal the confidential source?
Oh, I understand your question. So page 189 of the Joint Appendix, when it talks about the scope of withholdings, and particularly in paragraph 60 of this page of the Joint Appendix, it explains that, often the confidential sources here are foreign financial intelligence units. And it says that the information exchanged is so closely tied to these foreign jurisdictions and their sources that revealing even the substance of the information exchanged would reveal the identities of the sources. So for example, in a more typical case, if the confidential source is like an individual providing information, let's say to the FBI, if the information is something like, there are illegal drugs in X house, that kind of information is not so closely tied to the source. Like it could have been a number of individuals who said that. But here, in this fairly unique situation where the confidential source is often a foreign agency or a foreign law enforcement authority, and they provide information that's something like, this particular financial institution in this particular country had these suspicious transactions. That information about, where that foreign institution is, what country it's in, those provide very clear clues to what foreign intelligence unit is providing this information. So that would reveal the confidential source.
Counsel, do you have more that you want to say about other issues, or?
No, if this court has no further questions, we'd ask the court to affirm.
Let me make sure my colleagues don't have any further questions for you.
Nothing.
Okay, thank you, Ms. Chung. Mr. Gordon?
I'm sorry to be late about this, but
Sure.
I'd like to ask counsel for the government. Appellant makes a number of statements regarding, he understands that it may well be true that viewed globally, there is an exemption entitling the government not to release a document. But there may be documents within a group that are not of that kind. And the government hasn't indicated that there are not such documents. What is your response to that?
Sure. So I would point the court to page 172 of the Joint Appendix. So this is the discussion of Exemption 7A.
Right.
The declaration makes clear that the specific records in this case are related to the particular ongoing law enforcement proceedings. So we're not just saying that, FinCEN should get this blanket degree of confidentiality for all of its documents. We're tying very specifically here these documents to this ongoing law enforcement investigation. And the declaration says that foreign authorities have confirmed to FinCEN that these foreign investigations and proceedings are still pending into the facts underlying the Section 311 rulemaking and persons related to BPA.
So exactly, 172, which paragraph?
That's JA 172, it's paragraph 20.
So the way you read that,
it carries over to 172.
Yeah, so the way you read that, there is no room for the circumstance that appellant's counsel suggests.
Correct, Your Honor. If all of the documents at issue are related to the particular ongoing proceeding, and FinCEN, in its expert judgment, has said that release of these documents would interfere with that ongoing proceeding, then there is no room for release of those documents.
And given the presumption that the court attaches to the declarations by the government, we would not find the district courts, or would we, refusal to conduct an in-camera inspection and abuse of discretion. I'm trying to understand, and it must be that in those other cases, there simply wasn't this type of assertion by the government. That's what I'm trying to be clear about. As at JA 172, paragraph 20.
Your Honor, where the government has submitted sworn declarations explaining that there is an ongoing law enforcement investigation or proceeding, and that the documents at issue are related to that specific ongoing law enforcement investigation or proceeding, and disclosure would interfere with it, the court provides a presumption of good faith to the government declarants, and it defers to the agency's predictions of the harm that would occur. And this court has also said that the decision about whether to conduct in-camera review is left to the broad discretion of the district court. And here I think the district court explained its reasonings for not doing in-camera review, and there's no reason to doubt the district court.
So where we have remanded for further explanation by the agency, etc., there must apparently have not been this type of statement. That's all I'm trying to understand. Because counsel cite the cases where we have expressed some concern and we send it back for further articulation by the agency, not second guessing the agency, but just saying we can't tell from the generality of the statements in the declarations whether or not, in fact, these particular exemptions are properly invoked. And your argument is here just the paragraph 20 statement does that.
Yes, Your Honor. I think paragraph 20 statement does that, and just to provide a little bit more detail. The paragraph 20 says that the ongoing investigations relate to the Section 311 rulemaking and BPA. And then if you look at the public notices about the Section 311 rulemaking, this provides additional fact. So they explain that high-level managers at BPA assisted third-party money launderers who were involved in organized crime, corruption, smuggling, and fraud.
Right.
There's no case law that says we have to provide any further details about these investigations. In fact, this court in Boyd rejected basically this argument. In Boyd,
that's an important point, isn't it? That it's not just paragraph 20, but it's looking at the record that is available, and we have this rulemaking, so that paragraph 20 has to be understood in that context.
Yes, that's correct, Your Honor.
Thank you.
And I was going to explain that in Boyd.
Yeah.
The government made this same kind of description. It described the investigation as relating to targets who are individuals in some degree connected to or related by Boyd, who is the plaintiff in that case who had been convicted on gun and drug charges. So I think here we're providing about these investigations. And I would emphasize that Exemption 7A is intended to protect the integrity of the investigation, and that the government is not required to provide specific details about who the targets are and who's being investigated, as that could interfere with the investigation. If this court has no further questions, we would ask the court to affirm. Thank you.
Thank you, Ms. Chong. Mr. Gordon, I think you had 2 minutes left for rebuttal.
Thank you, Your Honor. Just to address Judge Rogers' point, with respect to paragraph 20, the JA 172, that is the type of broad description, facts underlying the 311 rulemaking, persons related to BPA, we're told high-level managers, money launderers. That's the type of multifaceted investigation that this court addressed in CREA, not in Boyd. Boyd was what CREA called the typical case, where you have a proceeding and you have the agency that's conducting the proceeding. That's not what's going on here. If you go look at the 311 rulemaking and then see how many different aspects there are to it and different people involved, I think the logical question would be to ask, okay, now tell me about the ongoing proceedings so we can see whether there's really any overlap. And that's the piece that's missing. So let me turn also then to the 7D issue. We were looking at the joint appendix, and I would ask the court to look at paragraph 34, for example, where Ms. El-Hindi says that information provided by confidential sources is often singular in nature. Not always, but often could reveal their identities. So the issue here isn't whether the sources are confidential. The issue is whether it's sufficient that they ask for the confidential treatment of their information, even if the information would not reveal their identity. And that is what FinCEN is doing here, because it believes that its obligations of confidentiality supersede its FOIA obligations. and it is only entitled to withhold the information if it would reveal the identity of the source. Unless the court has any questions, but I believe my time is up, so I will yield.
Thank you to both counsel. We'll take this case under submission.
Getting breakup in this one, this last one.
Yeah, for the government, yeah.
I was getting sound breakup, yeah.
Case number 19-1091 et al. Public Service Electric and Gas Company petitioner versus Federal Energy Regulatory Commission. Mr. Longstreth for the petitioner, Ms. Rylander for the respondent.
Counsel, Mr. Longstreth, please proceed when you're ready.
Thank you very much, and may it please the court, your honors. John Longstreth for the petitioners, Public Service Electric and Gas Company and PPL Electric Utilities Corporation. Two things stand out about this case. First, the commission repeatedly insists that this is essentially a one-off case. Its briefs note that the commission's findings were expressly limited to stability-related transmission upgrade projects, currently a category of 1, and makes repeated references to the case as unique or highly unusual. Now, it's conceptually permissible to have an agency one-off decision, but it does raise a suspicion that the decision is temporizing rather than fully reasoned and that ordinary process hasn't been followed.
Well, here is another aspect that's critical, that the commission was dealing with the same record in 2018 as it had in 2016.
That's correct, and as a matter of fact, that was just going to lead to the confirmation of the suspicion here that the commission did a 180-degree change in position in the orders on review based on the same record and barely acknowledged.
Why is that a problem?
Decision.
It said it's going to reconsider.
Yeah, why is that a problem? We do that all the time. I mean, we hate when we make a mistake, but that's exactly why you have rehearings. We've done, I mean, I laughed when I read this. I've gotten burned, as have my colleagues. You make mistakes. You look at a record and you swear you got it right. You publish it and you say, then you get a petition rehearing. You say, oh my God, we really screwed that one up. And you redo it on the same record. The same. I mean, the one thing I want to make clear here is what you're suggesting doesn't, at least to this judge, suggest anything that's horrible. It suggests exactly what we ought to be doing. This is what we do.
No, I appreciate
get it right.
Yeah, no, I appreciate, Your Honor, that the purpose of rehearing is that sometimes FERC does change its mind.
We all do. All judges do.
I think the one thing, though, that is clear here is not just that they changed their mind, but they changed their mind without any reference to the previous decision they had made. So it's one thing to change your mind and say, look, as you're saying, Your Honor, yes, I got it wrong the first time. Here's what I did wrong. Here's why I've changed my mind. Here's why what I decided before is no longer right. That's exactly what they did not do here. So if you look at...
So when the agency says, taking the same record, we're going to reconsider our decision, isn't that enough? I understand Supreme Court cases that talk about, well, you have to acknowledge you're changing your position and you have to tell us why, etc. And my only question is, I understand the nature of those cases, but I don't know that I read them quite the way you do in terms of saying that the agency cannot change its mind unless sort of it goes through this self-flagellation process.
Well, I'm certainly not suggesting that the commission needs to do that, but and you know.
But I mean, counsel, I'm not. It's really an unfair characterization. They clearly were explaining what preceded this and what happened here. It's a difference between solution-based for reliability as opposed to stability. They put it in that. Even I mean, Lord knows I don't sit around dealing with stability and reliability every day. But I got what they got, and it was very clear to me that they were making it clear to someone like me who might judge them and say, look, we put it in the wrong box, and this is a really unusual case. And that's the one thing that seems absolutely clear here is that the mistake was a mistake. It was an honest-to-God mistake. They put it in the wrong frame, and I don't know how you can doubt that. And they made it very clear what happened, and they made it very clear why they had to change. I don't think there's any confusion.
Well, let me tell you what I think, and I understand your point, Your Honor, that there was an explanation as to what they were doing, but what I was...
As against what they did.
But it's not...
They didn't. I got it. Now, like I say, I'm not someone who does this every day, but I clearly understood what they were saying about that. Well, they made a mistake with respect to what they did as against to what they are now doing.
Well, with respect, Your Honor, I don't think the thing that they didn't do was the first time they made when they made their first decision, they said there were going to be substantial benefits from this project.
Right. I can give you an opinion I've written where that's what I thought the first time, and then we reheard it, and I had to kind of eat crow and say, well, you know, that was wrong.
But Your Honor, I'm sure that you do that as a rational decision maker. That is not what FERC did here. FERC did not say, they never said there are not substantial benefits to these agencies. They never disavowed that finding. So the finding is, and so all they need to do to affirm their decision here is all they need to do to affirm the transmission operator's decision here. And again, we have to back up a little bit. The transmission operators are the ones that propose transmission cost allocations. That's our job as the transmission operators. Okay, it's not FERC's job to propose it. It's not the court's job to propose it. It's our job to propose it. And FERC has to affirm that if they find that there are substantial benefits to the project commensurate with the cost. FERC found that in 2016.
And they made a mistake.
But they didn't say that.
They did. They said in this context, it doesn't work. That is what we thought in Order 1000 and applied to most of the cases. They said we still affirm that. That is correct. But we found out that in this situation where we're talking about stability is not reliability, it doesn't work. The frame doesn't work.
I'm sorry, they didn't. I'm sorry, they did say, yes, we think stability is a different situation. What they did not say is, we found substantial benefits and now we find there aren't substantial benefits.
Well, where did I get that from?
They never said it was wrong. They never said it was wrong. They never even addressed those findings of substantial benefits. That was made in the first decision. All they did in the second decision was say, well, even if all they did in the second decision was say, well, we might have something that works better in this case. That, with respect to the commission, is not the right standard. The commission cannot.
Well, I think what they were saying is their basic premise of Order 1000 is cost causation. That's the foundation. And they were saying that they missed the boat on cost causation the way they initially set it up in this situation. They were wrong. There may be a little bit, maybe tiny bits of benefit here or there. They weren't suggesting there are no benefits. They were saying the cost causation allocation was so far off that in this situation, we are obliged to change it. I don't know how I could have gotten that. Listening to you, I'm wondering now whether I was delusional. You just can't miss what FERC said. You can't miss it.
Well, no, let me ask you, counsel, because you started out by saying that the agency here proceeded improperly. And that's what I need to understand what your concern is. Judge Edwards has outlined why we all understand what it did. But what was improper about what it did?
Well, let me put it this way, and I certainly don't want to suggest anyone's delusional, but it does appear I have to change somebody's mind here, so I'm going to try to do that as respectfully as I can.
How about answering my question?
In the April, yes, in the April 26th.
Start with our colleagues.
Well, with all due respect, Judge Rogers, it did seem like you were kind of coming from the same place, so I didn't mean to deflect. Here's the situation. The April 16th order comes out. The April 16th order says, we have this rule in place. It is an ex ante rule. The whole point of an ex ante rule is it's ex ante. We have the rule in place before the project is proposed, so that we don't have all this litigation afterwards and all these lawyers and all these lobbyists and all these public officials coming in and trying to overturn it. That's what ex ante means. We've got the rule. We've adopted it. We found in 2013 and 2014 it was proper. And it applies to these projects, reliability projects like this one. So they approved it. And they found that there were significant benefits to the project. That takes care of cost causation. Cost causation.
If it's correct.
What?
If it's correct.
If it's correct. And if they think it's not correct, what they have to do is come back and say, we said there were significant benefits to the project, but we were wrong. There are not significant benefits to the project. They never said that. And they couldn't have said it. Going to your question, Judge Rogers, it's a procedural thing. How can you say we were wrong in an April 2016 decision if you never refer to that decision or discuss the reason of that decision? Look at the decisional paragraphs in the 2018 and 2019 orders. In the 2018 order, they have a paragraph that's about 3 lines long saying, here's what we decided in 2016. Then we never hear about the 2016 order again. It's not discussed. Its findings aren't discussed. Its findings aren't overturned. They just go on to something else and say, well, you know, we could have done something that was a little better.
So let me ask you.
The test is not.
In other words, I need to be clear on your procedural point. When an agency such as FERC announces it is granting reconsideration of its 2016 order.
Right.
It cannot, in your view, even where it's proceeding on the same record, act as though nothing happened before and come up with what I'll just suggest is a new way of looking at the record.
Yeah, I think that's correct. And I think the analogy I would use, and I understand the points that you're making, which is when the agency's in the same proceeding, that's a little bit different from looking at prior precedent. I would think of it more kind of the way Universal Camera looks at it, which is that, you know, that was the case. You had the ALJ made a decision, then the commission made a decision, and the question was, you know, how you look at that. And the court makes clear, as I think you're suggesting, the agency can change its mind. The agency can have a final decision. That's all fine. But the court does have to take into account, I think that's what that case said, is they have to take into account that you had an administrative law judge who made findings, and those are in the record, and they have to be dealt with. And that, I think, is the answer to your question, which is, sure, they can change their mind. Sure, they can come to a different conclusion, but they can't just ignore the fact that in April 2016, they came to the opposite conclusion, and they made findings in this very case that there were substantial benefits from this project. And then again, that ties into the...
So they made a specific finding. First of all, you're ignoring the fact that this all starts pursuant to a petition for a rehearing, which states the alleged mistake. That's the context. That's why we're not confused. There was also a dissent in the original opinion, which helps to frame it. So there's a very strong dissent in the first opinion, framing it. There's a petition for a rehearing. That's what FERC is acting against or pursuing to. That is the frame. There's a petition for, you're being very formalistic in a very strange way. I haven't the faintest idea if we send it back, what are we supposed to say? You know, add some words and say, gee, we made a mistake. They have a petition for rehearing which they're responding to, which says you made a mistake. And then their finding is solely relying on the solution-based DFAX method to allocate the blah, 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 that address stability of race issues does not allocate the cost of such transmission projects in such a manner, that, et cetera, et cetera. They made that finding as against in response to a petition for rehearing, which said the first disposition was wrong. And they are now saying it was wrong. They agree. They made the critical finding in response to a petition for rehearing. Now, if they had just walked in and there was no petition for rehearing and they just said, oh, incidentally, we're going to have a new opinion. And there's no frame or no framework whatsoever. And they just issued something. Maybe I could understand you, but you really are not being fair in characterizing. There was a lot of fighting. I mean, you're taking it so out of context. It's not fair. There was a huge battle. The overarching agencies weighing in, they have their white paper. Both sides were fighting like crazy for 2 years. Everyone disagreed and with strong concerns about what was going on. And then there's a petition for rehearing and FERC responds to it. Wait a minute, something happened here. I'm sorry, that was my computer. And so that's why I want you to understand why I'm not getting it. I think you're creating something that's just a fiction. If there was no petition for rehearing, then I, as a judge, I would say, yeah, that's strange. I know how an agency or a court could get out of that bind, but there was one here. There's a dissent and then a petition for rehearing, frames the issue, and then FERC makes its finding.
Okay. I think the problem and the thing that I think is missing here in the discussion is that, and I think the reason that the initial finding of substantial benefits from the project, which was never expressly addressed or overturned,
It is. Counsel, wait a minute. That is just wrong. FERC made a finding in its new order, which says, here is what we are concluding on the same record, which is absolutely inconsistent with what they initially said. They're clearly saying they were wrong initially. They said in the second opinion, what we said before is wrong. It doesn't work in this context.
Yes, but I think the point I'm trying to make is that I don't think FERC's explanation works, because FERC was not free on rehearing to simply say, we have a new method that we think might be better than the first method. They were not
all they're saying. They're saying what we did initially was wrong.
Right.
That's the key point. There could be a fight. There could be a fight over what they replace it with, but I don't understand you challenging that. They clearly said what was initially done was wrong.
Yeah.
I just looked at the finding. The finding is there.
Yes, but I don't think the finding is what they needed under their Section 206 burden, because I was saying under 206, they cannot simply find that we have a special circumstance here where we think this new approach would be better and that the first one is not right. They have to find specifically that the benefits are not commensurate.
Can I ask this question
from this project? But they found that there were significant benefits, and they didn't reverse that finding. So I think the problem.
Judge Srinivasan.
Excuse me. I'm sorry. Maybe my voice isn't coming through. But can I ask this question?
Yeah.
Are you able to hear me?
Yes, I am.
Okay. Thanks. So, to me, the way to understand the benefits question is this: that the original order in 2016 was framed around a particular set of assumptions about what the relevant benefits were, because the relevant benefits had to do with flow. But in 2018, there's a recognition that, wait, we're just conceptualizing this erroneously, because in the stability-related context, there's a different kind of benefits that come to the fore, and the benefits that come to the fore are the stability-related benefits. And so that's, in some places, but at least in paragraph 40 on JA 892. And so when you think about the benefits as being in the context of a stability-related problem that is remedied with stability-related benefits, then yeah, they might have talked about substantial benefits before, but it was a different framework for understanding what the relevant benefits were. And that seems like that addresses the substantial benefits description, because it was substantial benefits of a kind that were originally viewed to be the relevant field of benefits. And now we're talking about a different kind of benefits that we now understand is what's more apposite when it's a stability-related problem. And so therefore, I don't know that you have to explicitly say, and when we were talking about substantial benefits before, it was a different frame of benefits. Now we understand that there's stability-related benefits, and as stability-related benefits, it's not commensurate anymore to assign it all to Delmarva.
Well, I think you're right that they said there could be a different way of looking, or there is a different way of looking at the benefits when you're in a stability context. So if you go back and look, I mean, and I think you're sort of suggesting that we kind of have to infer what was going on, because they never say, here's the finding we made, and here's why we're contradicting that finding. And I guess I was more troubled by that than, certainly it seems Judge Edwards is, because he was able to discern the path, I guess, as it goes. But it seems to me that that's more than sort of a technical or formalistic problem in this case, because we as the transmission owners have the right to present this as long as it passes muster under the cost causation test. And FERC's finding of these substantial benefits, because no one is denying this energy goes to Delaware and Maryland. They get the benefit of it. This is nothing at all like the ICC case where Illinois is paying for something that's in New Jersey or out in the east part of the country. This is going right there. But so they made that finding of benefits, and that finding of benefits, if it is enough to meet the commensurate benefits test, means that they have to accept our allocation proposal. In order to overturn it, they have to find that it's not commensurate. And they did, as I understand it, and I agree, they did find it was not commensurate. But the problem is, in finding it wasn't commensurate, they didn't deal with their prior finding that there were substantial benefits here, and there was a lot of record evidence about the substantial benefits here, that Delmarva is a importer of power, that it had transmission constraints, that most of its energy comes from connections to the north. All those findings were in there that this is a benefit. And so the problem is, I think, not that they didn't make a finding that this new stability deviation method might not be proper. It's not enough for them to find that the new one has to be proper. They have to find the old one is improper. They did find the old one was improper, as Judge Edwards notes, but they didn't take into account the record. They didn't take into account their prior findings and all of the evidence that supported those prior findings, that there were substantial benefits to Delmarva. Yes, maybe in a stability context, there might be benefits to other people. And if you look, it's not in the commission's order, but if you go root around in the technical transcript that Ms. Rylander cited to, they point to PJM, and PJM talks about how these stability violations are different, and they say, yeah, maybe you could find an additional beneficiary. Maybe this doesn't capture all the beneficiaries, but the point for our purposes is pollution-based defects does capture the user beneficiaries, and that's enough. And it's particularly enough in the context of 41000.
Excuse me. I think we understand that part of your argument. Let me make sure my colleagues don't have further questions for you at this point, because maybe you mentioned Ms. Rylander. Why don't we give her a chance to make her argument, and we'll give you a bit of time for rebuttal, unless my colleagues have further questions for you at this time.
Fine.
Okay, thank you, Mr. Longstreth. Let's hear from FERC counsel, Ms. Rylander.
Good morning. May it please the Court, Elizabeth Rylander for the Commission. To briefly recap what we've heard already, it is correct to say that when the Commission grants rehearing, what it's trying to do is get to the correct answer. And in this case, the two very thorough orders the Commission issued in 2018 and 2019 go to extensive effort to grapple with the record, to look at what the Commission had not discussed in 2016, and to arrive at the correct answer that the proper way to measure benefits of a stability project is not to follow the flow of electrons to whatever terminus PJM as the system operator has chosen for the new project.
Well, could I ask you, the Commission says clearly in paragraphs 66 and 67 of the 2018 order that it disagrees with these other arguments. It's taking this position. Where did it respond to the concerns addressed about Order 1000, that the benefits of knowing what the rules of the road are in advance captures so many important things? And I'm looking at what the Commission has said, specifically, here I'm looking at the 2018 order, sort of starting around, paragraph 64 and going through, let's see, 69. But I don't see that it just, until 74, it says, commenters raise concerns that the solution-based method may encourage selection of projects based on voltage or cost rather than efficiency or cost effectiveness as directed by Order 1000. And the Commission, this is paragraph 74, simply says there is no evidence here. Is that its complete response to the concern about Order 1000?
I'm sorry, Your Honor, I'm having trouble finding the place in the order that you're looking.
Paragraph JA 544.
I'm sorry.
Paragraph 74.
Yep, the Commission, the Commission did, with regard to Order 1000, the Commission did not make a finding that the selection of the project was done incorrectly. And what they're saying here is there's no evidence to support the contention that the project selection was incorrect. So it's hard to know exactly what the Commission was thinking there. There is evidence in the record that PJM had 26 options to choose from in selecting this project, and as quoted in a later order, that PJM chose what it viewed as the least risk and a relatively cost-effective option for solving the stability problem. What Order 1000 requires is that is not that PJM select the least expensive or the easiest project to build, but something that is something that will improve efficiency and will have benefits for the entire region.
All right, but and I see it also. I even highlighted it in paragraph 72. It talks about Order 1000, but it does it ever address the fact not that it is suggesting that its change of method in 2018 isn't correct in its view, but that it has no concern that this change will adversely affect those affected contrary to the predictability but principle on which Order 1000 is founded. I know in your brief you say Order 1000 leaves open the method, just has some principles. All right, but I didn't see anything in the Commission's decision itself about that. I just wanted to be clear, because you're probably more familiar with this than I.
The Commission speaks broadly in the 2018 order about the importance of matching costs to benefits. Right. And certainly Order 1000's first regional cost allocation principle is that costs and benefits be allocated in a way that is roughly commensurate with one another. If I'm understanding Your Honor's concern correctly, it's that the Commission arrived at this finding following the selection of project and following what was intended to be an ex-ante allocation of costs.
And the submission of the proposed tariff. So yes, the entities have proceeded on the basis of the 2016 order. Now the Commission is reconsidering and saying, we have to change our mind. are the concerns that are addressed in my question matters that would come up later in commission proceedings, namely when it reconsiders the submission? I just want to understand, in the whole idea was I get to know what the rules of the road are in advance. So I proceed on that basis. And I submit this proposal to the Commission on Tariffs, et cetera. Then the Commission says, we have decided for excellent reasons that we want to adopt a different framework. And that framework makes much more sense, and it's consistent with a statutory directive. And is this going to apply? Am I just caught? That's what I want to understand. Do I get some relief further down the road?
Counsel, can I add on to that? I don't think there's any reliance interest that they can properly argue here.
I was asking counsel for FERC to tell me that.
Yeah, no, I was just adding my question to yours, Judy, so she would answer it within the frame. But I'll let her answer yours first. Go ahead.
But this was raised by, before the commission, and I just didn't see it ever answered it. That's all.
So again, Your Honor, the Commission's overarching responsibility is to ensure that rates are just and reasonable, and both these orders and Order 1000 share that goal. The departure from the rate approved in the 1000 compliance filing is certainly not what the parties were necessarily expecting. But we're still dealing with the same project, and in addition to complaint orders on review here, there was a parallel parallel case under Federal Power Act Section 205 that allocated the dollars specifically. So while the cost allocation in an ex ante was held out ex ante in terms of this is what you can reasonably expect, in terms of boiling it down to dollars, that requires a separate commission approval on a separate track. And both those proceedings leave room, as here, for the commission to look at the overall picture and say, this doesn't work. And which is also consistent with the statute and also in furthering the goal of just and reasonable rates. This is not, I would say this is not necessarily an optimal way to establish expectations and to allocate costs under the broad theories established in Order 1000 and implemented in the compliance filings, but in service of the statute, that's what was required here.
Can I add?
Yes,
I want to add.
You're asking about reliance.
Yeah, make sure I understand. My sense is no one can reasonably claim, but wait, I had a reliance interest and I did something I wouldn't have done had I known we would end up in this place. That's not what I'm understanding. My understanding is that the commission has simply said, they made the finding here that opposing counsel has been arguing about, that the benefits were not commensurate with costs, which is Order 1000.
Yes.
And that's the foundation for the new order, and that answers any concern that opposing counsel is raised if the commission is correct, and they are correct. They are saying in this frame, we missed it. It's not that there are no benefits. There are benefits, and they may even be more than a little bit, but Order 1000 says benefits have to be commensurate with costs. And they fixed it. They said in this framed situation, we were wrong in suggesting that. And I want to make sure I'm correct. I don't see any viable reliance interest where anyone would say, oh, wait, you can't do that because I did X and I wouldn't have done X. The project's a good project. It was going to go ahead. And then you have to figure out how you're going to allocate the costs. Am I understanding it correctly?
Yes, Your Honor, you are. And I would add that it is, I view it as consistent with Order 1000 to get that cost allocation right, even if that has to be done as it was here, which was in a way that was somewhat different from what the parties would have thought at the time the project was chosen. I would also add, again, and this is clear in the record, PJM, which is the independent transmission operator, chose the project. It is not that the parties are choosing it and then allocating the costs among themselves. This was done independently and without PJM does not have financial interest in.
That's part of what I was trying to ask on the reliance claim. It's a PJM makes the determination, and we need this project. Then you go through the fight over benefits and costs.
Yes.
Okay. I understand. Thank you.
Okay. Okay. And to finish following up on Mr. Longstreth's argument, I'd like to clarify that FERC did not just swap in a new rate into these 2018 and 2019 rehearing orders. The 2018 order found that the initial cost allocation was not effective in a stability setting and that further proceedings were necessary to identify a replacement rate. As the court those further proceedings were held in the form of a paper hearing, and as the court has already observed, the outcome of the paper hearing and the resolution of the rate issue are not at issue in this case because the petitioners didn't seek a hearing of them before the commission. All that the court needs to look at here is the commission's decision that because of the definition of benefits that was used in Order 1000 compliance and used in this case, the original flow-based method was not appropriate to a stability project. I'm happy to answer further questions if the court has more.
I don't, Tree.
Okay, thank you, Mr. Allender. Mr. Longstreth, you have 3 minutes for your rebuttal.
Thank you very much, Your Honors. And I'd like to go to the points about Order 1000 because I think that really is important to where we are here. Again, Order 1000 was designed to set an ex-ante rule that was easily administrable, unknown to the parties, and that would avoid litigation over cost allocation by people who are unhappy with the decision. And so to the extent there's a reliance interest, I think much of what Judge Edwards says is correct, but the reliance here was, I think as Ms. Rylander conceded, we knew we were going to have this rule in place, and we knew this rule was going to apply and basically even out over projects based on the fact that we could tell who the users were, and that's how it would be applied. And the thing that FERC never addressed, the arguments that FERC never addressed were how this is consistent with that ex-ante portion of Order 1000. Yes, it is true that under Order 1000, the costs have to be commensurate with the benefits. But that gets back to the point that I was making before, which is there's no question there are benefits going to Delmarva, and they could, as Judge Edwards noted, even be more than the sum benefits that they've been trying to minimize it as being. If, in fact, there are substantial benefits, then the solution-based defects does meet the commensurate benefit test. And FERC's finding to the contrary, because it did not consider that fact, it did not consider its prior finding, is just not supported. Yes, they made the finding, but it was not proper for them to make that finding without considering and specifically addressing their prior finding that there were substantial benefits. And the reason that's important is because if, in fact, the solution-based defects is close enough here, we as the transmission owners had the right to rely on the fact that that was the rule and that was going to be applied in all cases. And we were not going to be faced with a decision where somebody unhappy with that decision after the fact was going to be able to come in and overturn the decision. In other words, if you have a rule that's going to work out over time, and these are benefits over time. The other advantage is the whole idea also of ex-ante was, and this was in the compliance order, we're not looking at the violation. We're not looking at, this is a stability violation and this is the reason that we're putting in the project. We're looking at who is using the project and who is using the project over time. And over time that will work out, and the transmission owners recognize that. Where it will not work out is if the commission comes in after the fact and says, well, in this particular case, we've got one we might like a little better. We're not expressly finding that this isn't, that the first one wasn't permissible, but we're going to change it. That upsets the whole system, and it upsets the whole idea of an ex-ante system. And that's the one thing that I think, as Judge Rogers noted, FERC never dealt with that argument. FERC never explained why its ruling wasn't going to upset this whole ex-ante system that they had put in place. Thank you.
All right.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Monday, January 25th at 9:30 a.m.
$30 minutes, Tree?
Yeah, why don't we do noon? Can we do noon, not at noon?
Fine with me. Is that all right with you, Judy?
Yeah.
I'll
Okay.
send you a link. Thanks.
Okay. All right. Thank you.
Goodbye.